30 years ago, the U.S. Supreme Court handed down a landmark decision, Plyler versus Doe. In 1975, the state of Texas had passed a law that allowed public schools to refuse admission to children who were undocumented. The law also withheld state funds from local school districts if they were to be used for education of undocumented kids. In the Plyler case, the court struck down the Texas law and held that it's unconstitutional to deny public education to children on the basis of their immigration status. Justice William Brennan, who authored the opinion, wrote, and I quote, "By denying these children a basic education, we deny them the ability to live within the structure of our civic institutions and foreclose any realistic possibility that they will contribute in even the smallest way to the progress of our nation." The year was 1982, and in the 30 years since Plyler versus Doe was decided, millions of immigrant children have received an education and become contributing members to America and society. They are today's doctors, soldiers, teachers, engineers, and they make us a better nation. But since it was decided, Plyler has been under attack from anti-immigration forces. On the very day the decision was announced, there was a lawyer at the Justice Department who wrote a memo criticizing his superiors for not arguing in support of this Texas law that was stricken by the court. Keep in mind, at the time Plyler was decided, the Justice Department was not under the control of a Democratic president. Ronald Reagan was president. Who was the Justice Department lawyer criticizing the Reagan administration for not being tough enough on immigrant children? His name was John Roberts. 23 years later, in 2005, he was nominated to be Chief Justice of the Supreme Court. During his confirmation hearing, Chief Justice Roberts said that he would not vote to overturn that case. And he said it was, quote, well-settled law. For example, he said Brown versus Board of Education, the Supreme Court decision that ordered desegregation of schools, was also well-settled law. Plyler versus Doe is often called the Brown versus Board of Education of the immigrants in America. But when I asked John Roberts whether he considered Plyler to be well-settled law, he refused to answer my question. Over the years, there have been attempts to pass federal legislation overturning this Supreme Court decision. In 1996, Congress was considering a bill to restrict illegal immigration. Representative Elton Gallegly, a Republican from California, offered an amendment to overturn Plyler versus Doe and permit states to bar undocumented children from public schools. At the time I was in the House, I voted against the Gallegly amendment. So did most of the Democrats. But most Republicans voted for it, and it passed. President Clinton threatened a veto if the Gallegly amendment was included in the final version of the immigration bill. And the amendment was also opposed by a bipartisan group of senators, including the late, great Senator Ted Kennedy and our colleague, Senator Kay Bailey Hutchison of Texas. As a result of this opposition, the Gallegly amendment was dropped from the final version of the bill. The latest threat to Plyler versus Doe is a spate of state laws targeting legal and illegal immigrants. On June 9th, 2011, 1 year ago this week, Alabama Governor Robert Bentley signed into law HB 56, the strictest immigration law in the country. Under Alabama law HB 56, it is a crime for a legal immigrant to fail to carry documents proving his or her legal status at all times. Police officers in Alabama are required to check the immigration status of any individual if they have, quote, reasonable suspicion that he or she is undocumented. I'm especially concerned about the provisions of the Alabama law that involve schools in enforcing immigration laws. For example, in Alabama, schools must check the immigration status of every student and report that information to the state. And schools are authorized to report students and parents they believe to be undocumented to the federal government. Last year, the U.S. Justice Department and the U.S. Education Department sent a letter to every school district in the country warning that enrollment practices that discourage students from attending school could violate federal civil rights laws. The letter reminded school districts of their obligation to provide access to undocumented students under the Supreme Court's decision in Plyler versus Doe. Supporters of the Alabama law argue that it doesn't prohibit immigrant children from attending public schools, but involving schools in enforcing immigration laws will clearly discourage immigrant children from attending. Last month, Tom Perez, the head of the Justice Department's Civil Rights Division, sent a letter to the Alabama Superintendent of Education about their department's investigation of Alabama's HB 56. Mr. Perez said the Justice Department has concluded that, quote, in the immediate aftermath of HB 56 implementation, Hispanic student absence rates tripled, while absence rates for other groups of students remained virtually flat. And the rate of total withdrawals of Hispanic children substantially increased to 13.4% of all Hispanic students in Alabama schools. Mr. Perez also said Hispanic children reported increased anxiety, diminished concentration in school, deteriorating grades, and increased hostility, bullying, and intimidation. The author of the education provision of the Alabama law has made it clear his real goal is to overturn Plyler versus Doe. If this challenge should make it to the Supreme Court, it could find a receptive audience in the Chief Justice, who criticized Plyler versus Doe when it was decided and refused to say it was well-settled law when he appeared before the Senate Judiciary Committee. I think this is the wrong approach for America. Instead of challenging Plyler versus Doe, we should be building on its legacy.